Welcome everybody to our Ethics MCLE today. For those who don't know me, my name is Katherine Ruschen. I'm a partner in the insurance practice at Bartier Perry, and I'll be presenting today with my co-partner in our commercial disputes team, Jennifer Shaw. If you have any questions during the course of the presentation, please feel free to use the chat function and send those questions through. Time permitting, we will do our best to answer them today. If not, we're happy to answer questions afterwards by email if you want to get in touch with us. So today we will be looking at complaints to the Office of the Legal Services Commissioner, and I'm going to give you some insights into how to handle a complaint if you are the unfortunate recipient of one, or you might be assisting a colleague to respond to a complaint. Then Jennifer is going to discuss disclosure obligations, including offences and show cause events, and then we'll both look at some case studies in the context of those two topics. So case studies in relation to suspension from practice and striking off from the role. We are having some technical difficulties today, so it may be that I'm unable to throw over to Jennifer. If I can't, then just bear with us for a couple of moments and you'll come back to me, but hopefully, fingers crossed, it all goes to plan. So first of all, I just wanted to give some insights about best practice approach to complaints. Just up on the screen now are some of the more common types of complaints. Probably the most prolific is in relation to costs, things like overcharging or excessive charging in relation to costs, non-disclosure, failing to provide updated estimates, that sort of thing. That's probably followed closely by neglect and undue delay in carrying out the work. But other areas that are cause for concern are things like misleading conduct, so misleading your opponent, the court, or even sometimes your own client. Discourtesy, so discourteous correspondence to your opponent or the court or a third party. And some of the other ones that do come up but are probably less common are inappropriate use of discovered documents obtained in proceedings, making improper threats to the other side or to third parties, pleading fraud without a proper basis. The list does go on. You'd be very surprised the sorts of things that happen and are the subjects of complaints. Some stuff you just can't make up. So what do you do when you get a complaint? So first of all, just briefly, up on your screen are the basic steps of the complaint process. So you will be notified by the regulator. So you'll be notified by either the Office of the Legal Services Commissioner, or if you are a solicitor and they've delegated to the Law Society, you'll get that notice from the Law Society. If you're a barrister and it's been delegated to the Bar Council, then you'll get the notice from the Bar Council. There may be an investigation depending on whether the regulator considers there is sufficient information with the complaint to determine the complaint, or whether they require further information. If they have sufficient information or they have an investigation, at the close of the investigation, you do have an opportunity to provide a response, and then you'll receive notice of the outcome of the response. Now, if the outcome proposes adverse action under Section 299 of the Uniform Law, then you will get the notification in draft form, effectively, of that proposed action, and you'll have a further opportunity to provide submissions in reply to that proposed action. The first thing I always say is you should make sure that you are familiar with the legislation that regulates the conduct of complaints. Just like you would in any matter that you're dealing with in your day-to-day legal practice for a client, you make sure you are at least have a general understanding of the applicable legislation. So if you are facing a complaint, it's a good idea to familiarise yourself with the obligations that you have in the complaint process and also the obligations of the regulator. So these are some of the pertinent sections in the Uniform Law. There are time limits under Section 272, which is 3 years from the conduct. There is discretion for the regulators to deal with the matter out of time if they consider it just and fair to do so, or in the public interest, but you do have a right to make submissions as to why it shouldn't be heard or determined out of time. For example, if there's prejudice. Be aware of Section 278, which gives the power to suspend immediately whilst the complaint is being determined. So that means, depending on the nature of the conduct, they can suspend if they think it's warranted in the public interest. That does not mean that the complaint is substantiated, but it simply means that they're taking that step in case the complaint is substantiated and the conduct is such that it would warrant that suspension. I've dealt with notification, the right to make submissions. The investigation powers are contained in section 282 and also chapter 7 further sets out the investigation powers and contains provisions that allow the regulator to compel further information or documents to be provided from either yourself or a third party. There's also section 282, which allows the regulator to extend the scope of the investigation. So quite often the complainant is akin to a self-represented litigant. They don't know how to properly articulate what the true issues are when they make their complaint. If you receive a complaint and you are aware that there are other matters that could have been raised, be prepared to meet those, because it is likely that they will be identified by the regulator in determining what steps to take and how to investigate, and they will become part of the investigation. Unsatisfactory professional conduct and professional misconduct, you should just be generally aware of the distinction between those two in the legislation. And as I mentioned briefly, section 299 limits the regulator's power to deal with matters in-house, so to speak. So they have the power to determine unsatisfactory professional conduct and impose a penalty of a type that's listed in section 299. However, if they determine that the conduct is professional misconduct, they have to commence disciplinary proceedings and make that contention, and it is up to the tribunal to make a finding as to whether it is professional misconduct. I've talked about your obligations effectively, but it's always useful to know what the obligations of the regulator are. We do have a habit of assuming the regulator always does the right thing, but just be mindful that it is a team of employed solicitors at the Law Society, for example, or the Bar Council that deal with these matters. There are varying levels of experience and expertise within that team, and sometimes, just as it does in any practice, things there's an oversight or something is done differently than the way perhaps it should be done. So you may have to pull them up on that. If you do have cause to do that, you should obviously do it in a diplomatic and polite way, as you can. But there is a duty to deal with complaints efficiently and expeditiously in section 317. There's a duty to give written notice of certain matters. And one of the most important ones, I think, is the duty to apply the rules of procedural fairness under section 319. Now, in my practice, in acting for legal practitioners in response to complaints, have had to raise section 319 a few times over the years. So don't assume that procedural fairness will always be given. In one matter, we were not given full particulars of the complaint, and so we determined that we weren't able to properly respond in submissions in reply without the full particulars. Now, initially, the regulator relied on section 279, which only says that they have to provide details of the complaint. It doesn't say that they have to provide the whole complaint itself. So they resisted initially, relying on that section. We wrote back and raised section 319, and in this particular matter, they were very serious allegations, and on that basis, we said that our client was entitled to know the full extent of the allegation, and they conceded to that position, and we ultimately got the full particulars and the full copy of the complaint. In another matter, we were given a heavily redacted affidavit from the complainant and a notice compelling my client to provide responses to each of the allegations made in the affidavit. Now, again, it's possible that many of those paragraphs remaining in the affidavit were out of context by reason of the redactions. So we pressed for a full copy of an unredacted version of the affidavit, initially resisted again. We went back and politely raised section 319, and ultimately we received the unredacted affidavit so that we could properly respond. So it does happen from time to time. Also, one section that's quite often overlooked by persons dealing with complaints is section 321 and the waiver of privilege if your client is the complainant. On so many occasions I've seen lawyers respond thinking that they cannot use documents from the client file that might assist their position in response to the complaint because they are privileged. They're not privileged if your client has made the complaint. There's an implied waiver of privilege in the making of the complaint. Similarly, if there are documents that do not advance your case in reply, you may be compelled to provide them. I've also seen lawyers try to resist section 371 notices for production of documents on the basis of privilege. That cannot stand under section 321 where the client has made the complaint and you must give up the file. If it is a third party complainant, so someone that you did not act for, it is better to insist that they be compelled to produce the documents rather than give those documents up, because there may still be a valid privilege claim in those circumstances, depending on whether your file you have access to privileged material, even though it was not a client. So the next thing, important thing, is just to remember your professional obligations when you're responding to a complaint. They equally apply in this process as they do to your day-to-day practice. There's a duty to respond in a conscientious and timely manner. And this is just one quote on the screen from a disciplinary matter involving a legal practitioner, but the courts and the tribunals remind us from time to time, quite frequently, that it is a very serious obligation. Also a duty to answer the complaint fully and frankly. The duty of candour that we all have in our day-to-day practice applies. So if you do make a mistake and it does happen where you fire something off to the regulator in response to a complaint and you realise that there may be something incorrect in that matter in your statement or whatever it might be, you have a duty to correct that as soon as possible, as soon as you become aware. And you do need to be careful about these things, because it is relatively common for complaints themselves to be unsubstantiated, but the lawyer finds themselves facing disciplinary action because of the way that they handled their response to the complaint. So for example, in this matter, the solicitor was brought before the tribunal. This was in Western Australia, where the tribunal found that he gave a deliberately misleading response to the committee, and the tribunal found that it was designed to avoid giving a complete explanation at the time, and this resulted in an additional 2-month suspension of his practicing certificate on top of the 3-month suspension that was imposed for the complaint itself. So he didn't do himself any favours. So just remember, giving a misleading response can also lead to disciplinary action. So I always recommend taking a positive approach to the complaint process. And what I mean by that is essentially these things. So don't procrastinate or ignore the complaint. You need to accept that receipt of an occasional complaint is likely a part of professional practice. It is in many professions, such as the health profession as well. If you ignore it, there may be nothing of substance in the complaint. And so, time and again, lawyers will go, well, that complaint is not even going to, go anywhere. So they don't respond at all. If you do that, similarly to misleading conduct, you could find yourself facing disciplinary action for the failure to respond. So respond in a timely manner. Use the opportunity to reflect. So even again, if the complaint has no substance, there are always things that could be done better, and it is an opportunity to have a look at that and perhaps work out whether things could have been done in a way that avoided the complaint being made in the first place. Also, if you take a positive approach, you might consider reviewing the conduct of your practice more broadly. So depending on the nature of the complaint, it may raise systemic issues that you need to have a look at in your practice. If you identify issues, then you should start making changes and improvements to your practice procedures, policies, whatever it might be internally, immediately. Because as we'll see when I look at the case studies, those changes and having commence them immediately, and being able to then give evidence of those changes can significantly mitigate the outcome of a complaint in terms of the penalty that's imposed. Also remember your audience. Don't be retaliatory. So there is every chance that your response will be provided to the complainant. So you should ensure that any mention of the complainant themselves in your response is appropriate and that it's done in a way that does not aggravate the matter further. It's always useful to express some empathy for the complainant in your response, even if the complaint is not substantiated. Okay, this is an important one because a lot of the matters that I receive, the legal practitioner has already given their first response to the regulator, and it's very hard to undo that position if it hasn't been an effective response or hasn't been the right strategy. So you need to consider, can you be objective in the complaint process? You might think you are, but I can assure you that in most instances, it's very difficult for anybody to remain objective throughout the whole process when you are the person that is the subject of the complaint. Many practitioners freeze if you've frozen, or there's some other difficult reason that you find it difficult to respond. Many occasions it's mental health issues, unfortunately. If any of these things apply to you, then you should get advice immediately. And also, in particular, if the complaint involves a serious allegation, then you should certainly seek advice. Now, you might be able to seek guidance or assistance from a senior practitioner in your firm or perhaps a mentor, and I highly recommend that if you have access to a person that can help you through the complaint process. But you should also consider obtaining legal representation. We're all aware of the saying that a practitioner who represents themselves has a fool for a client, and that applies equally to representing yourself in the complaint process. So in terms of strategy, this is, I think, the most important thing. Have a strategy. Have a strategy from the beginning. So as soon as you receive the complaint, work out what your strategy is. Is it going to be a mitigation strategy, or is a complete defence appropriate? Is it going to be one of insight, remorse and contrition, for example? And the reason you need to implement that immediately is because if it is a mitigation strategy, for example, you need to start taking the steps to show that you have made changes to prevent a reoccurrence of the conduct in the future already, before you become before the tribunal, for example, for disciplinary proceedings, before the regulator makes their decision. So think about whether you can show insight and remorse and how you might get to that position, and then how you might demonstrate that to the regulator in your response. Think about if you need to remediate, for example, if it involves misappropriation of trust monies, do you need to put the money back? And if so, you should do so immediately so that before you provide your response, in your response, you can say you have done this. Be flexible regarding acceptable outcomes. So think about what you want to avoid. Obviously, we all want to avoid suspension, cancellation, striking off. Are there other penalties that would be acceptable to you? And should your strategy be designed around that, encouraging the regulator to accept alternative options? So I will now hand over to Jennifer, who will discuss disclosure obligations and criminal offences and show cause events. Hopefully it goes seamlessly, but if not, it'll be thrown back to me. Okay.
Thank you, Catherine. I'm hoping everyone can see my screen. Perhaps the organisers could just let me know if my screen is showing. All good, great. Thanks very much, Catherine, and thanks for bearing with us. We did have some technical problems earlier, so fingers crossed. So I'm now going to give an overview of disclosure obligations, offences and show cause events. So what needs to be disclosed to the Law Society and when. So it's a statutory requirement of an Australian practicing certificate that the holder must notify the Law Society in writing within 7 days that the holder has been charged with a serious offence or a tax offence. And that's section 51 of the Legal Profession Uniform Law. So there's a form available on the Law Society's website, and you would usually attach your court attendance notice and police fact sheet to that. A tax offence is any offence under the Tax Administration Act, but what is a serious offence? Well, a serious offence is defined in the LPUL as an indictable offence, and or an offence against a law of a foreign country that would be an indictable offence if it had been committed in Australia. So there's no requirement to notify if you're charged with a summary offence, but if you're charged with an indictable offence or a tax offence, then that has to be notified in writing within 7 days. But what about convictions? If you are required to notify the Law Society in writing within 7 days if you're convicted of a summary offence, and that's because summary offences are prescribed for the purposes of Section 51 of the LPUL by Rule 15.2 of the Legal Profession Uniform General Rules. And you also obviously have to notify within 7 days if you're convicted of a serious offence or tax offence. There are some exceptions in terms of summary offences. You don't, for example, you'll be pleased to know, need to notify things like offences relating to parking of vehicles, and there are a few other exceptions. So what is a conviction? Well, take care because this does catch some people out. A conviction is defined in Section 6 of the LPUL as including a finding of guilt or the acceptance of a guilty plea by the court, whether or not a conviction is recorded. So if your matter is dismissed under Section 10 of the Crimes Sentencing Procedure Act or Section 32 of the Mental Health Forensic Provisions Act, then there is still that requirement to notify if the court has made a finding of guilt or has accepted a guilty plea, even if the conviction is not recorded. And obviously, if you lodge an appeal from your conviction, that doesn't alter your obligation to notify. There are a few other events that need to be notified within 7 days. For example, disciplinary, if you are the subject of disciplinary proceedings as a lawyer in a foreign country, or if you are subject to a bankruptcy-related event. Well, what's a bankruptcy-related event? That's also defined in Section 6 as becoming bankrupt in Australia or overseas. If you're served with a creditor's petition, if you've presented a debtor's petition, and if you've applied to take the benefit of any law for the relief of bankrupt or insolvent debtors. Now, some events, namely bankruptcy events and convictions for serious offences or tax offences, are known as automatic show cause events as defined in Section 86 of the Legal Profession Uniform Law. And for show cause events, if you are the holder of a practicing certificate, then not only must you notify the Law Society within 7 days, but you also have to provide a written statement explaining why, despite that show cause event, you consider yourself to be a fit and proper person to hold a practicing certificate. And that has to be provided within 28 days of the event. Similarly, if you are applying for the first time for a practicing certificate, then you also need to notify if a show cause event has happened at any time and provide that same show cause statement. Also, if you have committed if a bankruptcy related event has happened in relation to you, there's also a standard bankruptcy undertaking that has to be given. So what else has to be notified? Well, some disclosures are required to be made upon application for a practicing certificate. The Law Society must not grant a practicing certificate if it considers that the applicant is not a fit and proper person to hold the certificate. And when considering whether or not an applicant is fit and proper, the Law Society can have regard to the matters set out in Rule 13. And applicants have to address each of those matters in their application. And some of the most common ones I've set out here. So if you've been the director of a company, including an ILP, well, the company was insolvent, If you've engaged in legal practice in Australia when not permitted to do so, i.e. practicing without a practicing certificate or practicing when not admitted, or both. If you are subject to an unresolved complaint or investigation, if you're subject to disciplinary proceedings in any occupation in Australia or overseas, whether you've been removed from the role of any Australian jurisdiction or foreign role, if you've contravened any law in relation to trust funds, if you're unable to carry out satisfactorily the inherent requirements of practice, for example, if you're suffering from a particular mental health condition that might be impacting you or other health condition. And finally, whether you've failed to comply with the requirement of Australian law in relation to professional indemnity insurance. So what happens if you don't disclose, if you fail to disclose? Well, it can amount to professional misconduct or unsatisfactory professional conduct. The Law Society can refuse to grant you a practicing certificate, can cancel a practicing certificate, or can suspend a practicing certificate. And after you've made your disclosure, the Law Society will investigate the matter and determine what steps they're going to take next. So Katherine is now going to look at some case studies where the Law Society has brought disciplinary proceedings against practitioners seeking strike off from the role.
Sorry, I think I'm back now. Okay, so as I mentioned, first of all, a couple of cases I'm going to look at involved removal from the role, which is obviously the most severe penalty you could be facing. The cases show it's notoriously difficult to get back on the role if you are struck off. It is a protective order if it were made. The test effectively is whether the practitioner is presently and probably permanently unfit to practice. The onus is on the regulator to show probable indefinite or permanent unfitness to practice. And a strike-off order is not a final, it's not final. It used to be, there's some old cases that talk about it being a sentence of professional death, but it's not. But as I said, readmission is not common, unfortunately. And it would require as a minimum demonstration of a sufficient period of commendable conduct showing rehabilitation and fitness to practice. These are just the relevant principles. The gravity of the conduct is taken into account when considering a strike-off order. The deterrent effect, whether specific, that is to a deterrent to the particular practitioner guilty of the conduct, or a general deterrent as to whether it will have an effect of deterring other solicitors from engaging in similar conduct. And also the enhancement of confidence in the public in the integrity of the profession is taken into account. So the power to strike off is found in section 23 of the Uniform Law. The Supreme Court can order under that section that the name of the solicitor be removed from the role on the recommendation of the tribunal, and it is a statutory jurisdiction which supplements the Supreme Court's inherent jurisdiction. So the last thing that I mentioned when I was giving some insights in how you might handle a complaint was having a strategy, meaning that you don't just go through the motions of admitting, not admitting or denying each of the allegations against you, that you have a broader strategy of what you want to achieve at the end and how you're going to get there. And there's been two decisions in the Court of Appeal this year in 2020 that I think are very useful in highlighting how that strategy is useful. One shows effectively what not to do, and one shows what you can do. And I'll go through some other things that you could probably do better in that case as well. So the first case is a decision of the Court of Appeal in Yoon recently. Now, Mr. Yoon was found guilty in the Tribunal of Professional Misconduct for various breaches of the 2004 Act. It included misappropriation of trust monies and also a failure to comply with the notice issued under Section 370 of the Uniform Law. And as I mentioned, things you do in the complaint process can become the subject of disciplinary action. He did file reply documents in the tribunal, but he didn't appear at the final hearing. The Supreme Court, sorry, the Law Society then commenced the Supreme Court proceedings to remove his name from the roll, and he didn't file any response whatsoever to those proceedings, and he didn't appear in those proceedings. So in the reply that he did file in the tribunal, it fell well short of any kind of insight remorse mitigation strategy. And this is what he said in those documents. He did admit that he had no trust account, and he admitted that nonetheless he received money on account of costs. However, he said that he had a costs agreement that provisioned for the allocation of monies received in advance towards the payment of costs once they were incurred. So he thought that was okay. He also said he had the client's verbal authority to misappropriate the funds. And in relation to that Section 370 notice, which was a notice compelling him to provide his bank statements, he said he didn't comply because he thought the regulator could get those bank statements from a third party, namely the bank, under a subpoena. As a sort of side note, the conduct related to only one client involved a single instance of misappropriation. So that response did not demonstrate any insight or remorse. It did not demonstrate that he'd taken steps since the conduct had occurred in order to ensure that it wouldn't happen again. All it showed was that he had a lack of understanding, not just then, but also now, of his obligations in handling trust money. It showed he had a lack of understanding of the applicable law in relation to cost disclosure, both back when the conduct occurred and when the matter was before the tribunal. And so because of those things, it was considered that whilst it only involved one client, there was a real risk of repeat conduct of this type by this solicitor. So what was held in the Supreme Court, so then when it came before the Supreme Court held that he was not a fit and proper person to hold a practicing certificate effectively, and that it was in the interest of the public that his name be removed from the roll. And the basis of that was, according to the Court of Appeal, he had been found guilty in the Tribunal of Professional Misconduct. Misappropriation of funds, of course, is a very serious matter. The court has a duty to protect the public from misconduct of this kind, not just from this practitioner, but from other practitioners who might be expected to be deterred if appropriate sanctions are imposed against this solicitor. And also the court obviously must insist on the maintenance of the highest standards of honesty and integrity for legal practitioners. There is, to my mind, a problem with both the tribunal and the Court of Appeal decisions in Yoon, and that is that neither the tribunal nor the court determined the question properly of probable permanent unfitness. So the tribunal did note the correct test, which is up on the screen, and that's all they did. They didn't then say how they applied that test to Mr. Yoon. They didn't make any findings as to whether he's probably permanently unfit. It was limited to being satisfied that he was currently unfit to practice, which is not the correct test. Interestingly, the Court of Appeal neither referred to the test nor determined the question as to whether Mr. Yoon was probably permanently unfit. As I said, they simply made the finding that he should be struck off on the basis that he'd been found guilty in the tribunal and that he was currently unfit as well. So the question, I suppose, is would the decision be different if there were proper consideration of the probability of being permanently unfit? In my view, probably not. If the tribunal or the court had turned their mind to permanent unfitness, I think they likely would have found him probably permanently unfit to practice. And this is because he did not take any mitigation steps. His explanations, for example, that he could use the monies on paid in advance for costs because his costs agreement said so, demonstrated that a continuing lack of understanding that he had engaged in wrongful conduct. He had not demonstrated that he'd taken any steps or would take steps to gain a proper understanding of his costs, disclosure and trust obligations. And so there was no evidence to suggest there was a prospect he might become fit to practice in the future. And he had ample time to rectify that and put on that mitigation evidence, because this conduct all occurred many, many years ago, and he could have taken steps over the years it took to come before the tribunal. So the case that we can compare this to is also a case this year in the Court of Appeal of Sukovska. Now, she had a bit of a mitigation strategy that meant that she did not get struck off the roll. So she did escape that, which was the end goal for her. The conduct in question for, I'll call her Miss Z, was overcharging an elderly and vulnerable client, unreasonably establishing a trust structure in relation to the client's estate, making unsecured loans from the proceeds of sale of the client's home, including into a company that she controlled. So she was found guilty of 5 instances of professional misconduct in the tribunal and a further 5 instances of unsatisfactory conduct in the tribunal. So it might, on paper, seem that her conduct was more grave than the 1 instance of misappropriation by Mr. Yoon. So in the tribunal, even though the Law Society sought an order or a recommendation that she be struck off the roll, the tribunal did find she was not presently fit to practice. And they also went on to say that she could not have a realistic prospect of demonstrating she was fit to practice unless she acknowledged the entirety of her conduct, explained the steps taken and to be taken to prevent such conduct reoccurring, and also demonstrated a formal commitment to complete training that addressed these issues. But that doesn't go so far as to say she probably is permanently unfit. And on that question, the tribunal said that they weren't satisfied, whilst the conduct was serious and deserved condemnation, that it demonstrated she was permanently unfit to practice. Instead, they recommended to the Law Society that conditions of practice be imposed. Her practicing certificate was cancelled with a preclusion period of 12 months and a recommendation that conditions be imposed if it's reissued. The tribunal didn't go so far as to say to make orders as to what the conditions would be. That was because neither party had gone forward with any proposal, and the tribunal didn't consider its job effectively when no party had provided proposed conditions to actually make orders about that. At the end of the day, though, the recommendation to strike off the roll was not made because her case did not involve clear dishonesty, and that is, the cases will demonstrate a usual feature of cases where a solicitor is struck off the roll. It was related to only 1 client with no indication the conduct was repeated with other clients. There was some evidence of her inexperience and lack of training before she set up her own practice. But more importantly, in terms of the mitigation strategy, there was at least some evidence that she recognised and accepted that she had departed from the required standard of conduct. There was evidence that she had a genuine desire to continue to practice, and there was also evidence that she was prepared to undertake further professional education and training or be suitably supervised. And also, unlike Mr. Yoon, she had remediated. She had repaid the monies, the client monies. I think there are some other things she could have done that would have further enhanced her position. For example, she didn't have any evidence of contrition, and that was noted as a fundamental flaw by the Court of Appeal in her case. Whilst in the tribunal there was an isolated statement of deep regret in her affidavit for the substantive hearing, she didn't repeat that at the penalty hearing. She also didn't put on any evidence of her detailed evidence of her intentions to become a person that was fit to practice. For example, what steps she would take to ensure that such conduct would not be repeated. That might be, for example, identifying particular courses, not just saying loosely that you'll undertake training in relation to whatever the issue is, trust accounts, for example. So identifying actual courses, when they're available, how you're going to participate online or in person, showing that you're enrolled and so on. She also, as I mentioned, didn't draft and offer preconditions or conditions of practice. Now, you don't need to wait for the regulator to do that. You can always go in on the front foot and say, for example, if you're facing suspension, don't suspend me. Here's some conditions that I can accept, and they will obviate the need to suspend. I have done that a couple of times for clients I've represented, and on both occasions, it was apparent that the regulator hadn't actually turned their mind as to whether there were appropriate conditions in lieu of suspension. We drafted the conditions in consultation with my client as to what they could live with. We put that proposal to the regulator, and sure enough, they accepted it, and instead of suspending, which they had proposed to do, they simply imposed the conditions on the practicing certificate. She could have given a complete acknowledgement of her wrongful conduct instead of the partial admissions that she made. And as I said, evidence of the steps that she would take to ensure it didn't happen again. The Law Society, of course, wasn't happy that there was no recommendation to strike off the roll, so they took it to the Court of Appeal on this question. But the Court of Appeal also didn't agree that the test of permanent unfitness was satisfied. They said that there's an appreciable likelihood that there will come a time when she'll be fit to practice, and that preconditions and conditions of practice were required for the protection of the public, and if those conditions were satisfied, there's every chance that she would be able to establish she was fit to practice again in the future. So these are what the Court of Appeal said would be the preconditions, effectively, that she give a solemn statement acknowledging the entirety of her conduct, explaining why it occurred and the steps she'd taken to prevent it happening again, and also formally committing in writing to complete specific training. So lastly, just some takeaways. Those two cases demonstrate, I think, that you do need to think about the bigger picture and have a strategy from the beginning. Implement that strategy immediately and take immediate steps to prevent the reoccurrence. Don't do nothing like Mr. Yoon did. Take the steps, prepare the evidence. Do more than what Miss Z did. She did some steps, but not enough, arguably. Be able to demonstrate that you have an understanding as to why the conduct may have been inappropriate, or at the very least, even if you might be exculpated of the conduct, have an understanding and be able to demonstrate you understand why the complaint was made in the first place. Think about whether you can demonstrate insight and remorse and how you're going to do that. Do you need to prepare a self-reflection statement, for example, and that can become evidence before a disciplinary body. And then lastly, I think what the last case I mentioned tells us, that solicitor may not have ended up in the Court of Appeal if she went in on the front foot and had drafted proposed conditions. If there are conditions you're willing to accept and you think that they might point out to the regulator that they would obviate the need to suspend, cancel or strike off the roll, then draft those proposed conditions and make an offer about them, or at very least take them to the tribunal if you don't get anywhere with the regulator before that hearing. So I'll now hand back to Jennifer, who will look at some case studies in relation to disclosure obligations, criminal offences and show cause events. Thank you, everyone.
Thanks, Catherine. Actually, I'm now going to be talking to you about some cases regarding strike-off for criminal convictions. You might think that people would always be struck off if they were subject to a criminal conviction, but that's not always the case, as this case demonstrates. So in cases concerning serious criminal offences, for example, arising from conduct outside of practice of law, the Law Society can bring applications direct to the Supreme Court for removal of the practitioner's name from the roll. These applications are brought in the court's inherent supervisory jurisdiction, which is preserved by Section 264 of the LPUL. And a recent example of such a case is the Council of the Law Society and Parente. So in this case, the solicitor was arrested in the middle of the night in his car driving through Sydney. He had been stopped and his car was searched, and the police found a plastic bag containing 100 tablets, later analysed as MDMA, and located a litre bottle containing GBL. He also had $3,000 in $50 notes on his person. So he was arrested, taken to the police station. The police also executed a search warrant at his home and found further drugs. So he was charged with a number of counts of supplying prohibited drugs, to which he entered pleas of guilty. Now, the sentencing judge accepted that he was hopelessly addicted to ice and other drugs, and that following his arrest and subsequent release on bail, he saw a psychologist who was able to assist him in overcoming his addiction prior to sentencing, and that was a circumstance that the criminal court held went greatly to his credit, which led to the sentencing judge making a number of favourable findings, which were accepted by the Court of Criminal Appeal, including genuine remorse, no previous convictions, excellent prior character, excellent prospects of rehabilitation, unlikelihood of reoffending. But despite all of those factors, obviously the seriousness of the offending warranted a sentence of imprisonment. He was sentenced to 4 years with a non-parole period of 2 years. So the Law Society took him to the Supreme Court of Appeal, seeking a declaration he was not a fit and proper person, an order for his removal from the role, and costs. Now, the Law Society bore the onus of proof as to whether the solicitor was fit and proper to remain on the role, and that called for some consideration of present fitness. An order striking a solicitor off the role, as Katherine has said, should only be made where the respondent is at least indefinitely, if not permanently, unfit. The jurisdiction is protective. It's not intended to punish the practitioner. The protection in this context is concerned with the public who may deal with the practitioner, other members of the profession, and the reputation of the profession and the public's confidence in it. So the court actually in Parente did accept the submission that the solicitor was not a fit and proper person to remain on the role, and said that that flowed from the applications of the principles in Bar Association and Cummins, which concerned a barrister who was struck off for failing to lodge tax returns for, I believe, something like 38 years. The court said that honesty and integrity are important in many spheres of conduct. The legal profession has long required the highest standards of integrity. Clients obviously have to feel secure in confiding their secrets to their lawyers. Fellow practitioners have to be able to depend on the words and behaviour of their colleagues, and same with the judiciary. They need to have confidence in you, and the public have to have confidence in the legal profession. So the court held in Parente that there'd be an incongruity in accepting that a person still the subject of a 4-year sentence of imprisonment, albeit on parole, could be described as meeting the highest standards of integrity. But in terms of protection of the public, by the time of the hearing, there was evidence that the solicitor had overcome his addiction, and Brereton Jay said that, held that in his view, there was no purpose protective of the public that could be achieved by removal from the role. But what about protection of the profession and the public's confidence in it? Well, the court said that the court actually looked at 3 other cases where practitioners had been convicted of serious criminal offences where the practitioners were not struck off, and said that the modern profession can tolerate persons of otherwise good character who have once lapsed, even gravely, if satisfied that the conduct was irrelevant to their professional qualities or out of character. So what are those 3 cases that they looked at? Well, the first one is the case of Zeems. In that one, a barrister of many years standing and a good reputation was convicted of manslaughter by driving a vehicle while under the influence of alcohol, and was sentenced to 2 years in prison. The Supreme Court struck his name off the roll, but the order was reversed by the High Court, which substituted a suspension for so long as the barrister was actually in prison. And the rationale was that the conviction related to an isolated occasion and did not warrant any adverse conclusion as to the barrister's general behaviours or inherent qualities. And they said that once his sentence had been served, no real difficulty would be felt by fellow barristers or by judges in meeting with him and cooperating with him in the life and work of the bar. They also, in parente, considered this case of a solicitor and the Law Society of New South Wales. In this case, the solicitor committed 4 offences of aggravated indecent assault on 2 children, pleaded guilty. He was sentenced to 3 months in prison, and that was reduced on appeal. He also failed to disclose to the Law Society a later conviction, which was subsequently quashed on appeal. He was initially found guilty by the Supreme Court of professional misconduct due to the conviction and also his failure to disclose the later conviction. And he was held to be not a fit and proper person to be a legal practitioner. However, on appeal, the High Court held that the conviction itself did not amount to professional misconduct because it was so remote from anything to do with professional practice, held that the failure to disclose the later conviction was professional misconduct, and set aside the declaration that he was not fit and proper. The court said that the Court of Appeal gave insufficient weight to the isolated nature of the 1997 offences, the powerful subjective case made on behalf of the solicitor as to his character and rehabilitation, and the extraordinary circumstances in which the breach of duty of candour occurred, and concluded that the solicitor had not practiced for more than 5 years, and it would have been appropriate for the Court of Appeal to make an order for his suspension not extending beyond the present time. In parente, the last case that the court considered was this case of P. This was a solicitor who had been using cocaine and heroin for several years, had pleaded guilty to importing a trafficable quantity of cocaine at the last minute request of her then boyfriend as their flight from Argentina approached Sydney. The sentencing judge accepted that the importation wasn't committed for the purpose of commercial dealing with the cocaine, and that the drugs were handed to her only shortly before she reached Sydney. She was sentenced to 6 months in prison, but released after 3 months on entering into a recognizance to be of good behaviour for 3 months from her date of release. So she served her time in prison, and after 3 months she was released to comply and complied with her recognizance. And after she had served her sentence, the prothonotary applied to have her removed from the role. But the Court of Appeal accepted that the solicitor had been drug-free for almost 5 years, and that the factual matrix of the case was such that the solicitor was not a risk to the public, and in circumstances where the Law Society expressed the view that removal was not necessary, concluded that in light of her proven rehabilitation, the additional protection that she would actually have to apply to the Law Society for a practicing certificate, should she wish to resume practice, that there was no protective purpose to be served by her removal, so she was not struck off. So in parente, the court also had a look at the US and observed that in the US, drug offences tend to warrant disbarment, absent some compelling mitigating circumstances, such as these that are up on the screen. So absence of prior disciplinary record, absence of motive, of personal enrichment, honesty and cooperation with the authorities, and evidence of good character, any voluntary self-imposed suspension, the delay in commencing disciplinary proceedings, and most importantly, clear and convincing evidence of rehabilitation. Now in parente, the solicitor did not give evidence, and he didn't actually oppose the application. So the court said that in those circumstances in which evidence of rehabilitation and reformation is central, that deprives the court of the most important direct evidence and of the opportunity for it to be tested. And absent any evidence from him, they couldn't conclude that he would be fit and proper to practice. So they compared his case to that of P and said that objectively judged, the gravity of Mr. Parente's offending was much greater. He was financially motivated, acted with premeditation. His misconduct did have some impact on his professional practice, and his head sentence remained on foot. The Law Society had resolved that removal was appropriate, and he actually didn't seek to remain on the roll, and he hadn't adduced any evidence of his present circumstances, status, or intentions. So the court in Parente said that his lapse was great, and it speaks more adversely of his character than those of the practitioners in Zeems and P. And while the profession ought to be expected to allow some to be redeemed, it could be understood that as distinct from Zeems, a significant body of professional peers might well feel difficulty in meeting with him and cooperating with him in the life and work of the profession with the knowledge that he is a convicted drug dealer. So in conclusion, think about just be aware of the impact that your personal life can have on your right to practice. If you're charged with and or convicted of a criminal offence outside of the practice of law, be it domestic violence related, drug related, alcohol assault related, or if you're charged with a tax offence, or if a bankruptcy related event happens to you, then be aware of your obligations to notify and to show cause. When applying to renew your practicing certificate, carefully review Rule 13.1 and see if there's anything there that you need to disclose. And remember that the mere fact of a conviction in respect of a conduct outside of the practice of law does not mean that the person is not fit and proper to practice law, as we've seen from those cases. The circumstances underlying the conviction are relevant to whether a person remains fit to practice. And also the question of fitness is one of present fitness, not fitness at the time of the conviction. So in any disciplinary proceedings, it's important to front up and give your explanation and evidence to enable the court or tribunal to assess current fitness, so don't bury your head in the sand. And we've just got time for a few questions. 4 minutes for questions. I don't know if Catherine wants to join me on the screen in case there's any questions. We have got one question. Does a solicitor have an obligation to report a fellow practitioner's conduct to the Law Society? We do get asked that quite a lot. So the answer is no, not unless you believe on reasonable grounds that there's an irregularity in relation to trust accounts. So have a look at, I think it's section 154 of the Legal Profession Uniform Law sets that out. But otherwise, apart from trust account irregularities and problems with trust accounts, there's no requirement to dob in your fellow practitioners, so to speak.
And I'd also just add for that, unless it's the trust issue that Jennifer mentioned, if you are contemplating making a complaint about a fellow practitioner, I always say get on the phone and speak to them. See if you can resolve the issue between yourselves first before you actually take that drastic step of making a complaint. I'm sure that if you were on the other side, you would appreciate a phone call first. There may be, if it's a discourteous letter, for example, there may be something going on behind the scenes that impacted their conduct when they did that. It may be a one-off and they're willing to apologise, for example. Yep, I'd agree with that. Thanks, Catherine. Well, if there's no further questions, thank you very much for joining us this afternoon. I hope you've gained something from that webinar and that you found it interesting and informative. But if you've got any questions, our numbers and email addresses are up on the screen. Please don't hesitate to contact us. Thank you. And also, I had a couple of queries on a separate platform about the slides. They will be sent out, I think, a pack with the slides and a recording will be sent out to everybody who joined in today if you're interested in the material. Thank you, everyone.
Thank you.